How to keep your estate plan safe. My name is Michael Pevney. I am an estate planning lawyer and I set up estate plans for families in California. If you have any questions about estate planning, go ahead and ask them in the comments. Follow me for more estate planning information. And yes, I only practice in California, but some of this information may very well apply to you as well. So when I say keeping your estate plan safe, I'm talking about who should have access to it and where it should be kept. And I'm going to tell you what I do. For almost all of my clients, we set up an estate plan with 7, 8, 9 different documents or so. The central document is often a trust, a revocable living trust. And I do not keep the originals. You walk out of my office, or sometimes we handle things remotely, and you are sent the actual originals that are signed, the wet signature, the actual notary's stamp. So where do we keep this document? The general place I recommend that you do not keep the document is a bank safe deposit box. These are becoming more and more rare over time that people actually have a safe deposit box, but they can be difficult to access, especially after you've passed away, especially if the right people don't have the access or even a key to that deposit box and the right ID. So what often ends up happening is one of the reasons we set up a trust is to avoid the entire probate process, making sure that we want to avoid having a judge make decisions about where your assets go. We want you to make those decisions with as little government interference as possible. Sometimes when we keep these original documents inside of a safe deposit box, we have to go to court anyway and ultimately get a court order, and the guy with the drill has to end up coming out, showing the court order to the bank, and then we drill into that safe deposit box. We get it out, and then the original documents are in there. This might happen 6, 8, 10 months after the people have passed away. And if they had the trust available and accessible, it would have already been administered, and everything that's supposed to have happened will already have happened. And now we're just at the starting point. So no trusts in safe deposit boxes. Now we also want to make sure there are copies. And what I do typically is I make sure we have digital copies. We don't necessarily have to old-fashioned Xerox things, but we want to make sure that we have a high-quality scan of all of these documents, but they're not a scan of the draft. They are a scan of an original after it's been signed, after it's been notarized, so they are essentially an original copy. So after I do a signing at my office, we have everything signed, everything notarized, and I immediately scan all of the documents. Those documents are then given to all of my clients. I retain a copy of those documents as well, an original copy, and we want to make sure that the key people involved in your estate plan also have a copy and also have access to the original. They at least know where the originals are. And these copies can be either emailed to our decision makers, our next trustee. We can set up some sort of a Dropbox account that they get access to or a link to, because copies are oftentimes just as good as the real thing for many estate plan administration issues. After you pass away, we need to tell the records office that you've passed away and that the trustee comes next in line. Essentially, you file an affidavit saying that a trust exists, you are next in the trust, and a death certificate. Oftentimes with medical situations, an original copy can also be just as good when we're looking at what an end-of-life decision is and what an advance healthcare directive looks like. And those tell us what your end-of-life decisions are and then who are the decision makers for that. I am aware of situations where people will just pull up an email on their phone and show a medical professional what that person actually wants, as assuming that it's, of course, properly signed and notarized at the bottom. Now, as much as original copies are often good for every circumstance, sometimes an actual original is going to need to be shown. This happens oftentimes, most often at a bank, where we want to get access by use of a power of attorney to somebody that is still alive, but maybe they're medically incapacitated. So while copies are great for many situations, oftentimes we want to make sure that our decision makers, our power of attorney, our next trustee, has access at least to the originals. So they know where they're kept. If you keep them in a safe, they have a combination to that safe. So because that document often has to go to the bank, the original, to make sure that there's no sort of fraud going on, because banks have their boxes that they need to check. They need to watch out for fraud that's going on as well. So when there is a balance, and there is a balance between privacy and accessibility, and don't get me wrong, these are private documents, they are personal documents. They are not filed in California. They are not filed with any government agency, certainly while you are alive, unless there's some sort of litigation going on. Very rare that a trust becomes some sort of public record in any way. And that's one of the benefits of setting up a complete estate plan based around a trust, is you are going to get some privacy out of it. Check my other videos available on this platform for all of the other benefits of setting up a living trust. Yes, I am an estate planning lawyer. That is what I do for most of my clients. Now, what I like to do, at least when it comes to setting up a trust, and even though privacy is important and accessibility is important, is we want to keep some sensitive information out of the trust. I never put social security numbers in my trusts that I create for my clients. I don't think it's necessary, and it's just one more level of privacy that you get. I typically don't put actual account numbers in my actual trust documents as well. It's very important that the people that come after you, your next trustee, we have an idea of where accounts are held and relative balances in those accounts, but I don't see that it's typically necessary to keep actual account numbers in there. And after we set up a trust, we do need to make sure that those accounts are either placed into the trust or potentially making the beneficiary of those accounts the trust itself. But by keeping account numbers out of the trust, and by keeping social security numbers out of the trust, we do have a greater level of privacy and often confidence in letting the people, our next decision makers, know, our power of attorney, our next trustee, where those original documents are, and giving copies to them. We also want to be very careful about who we choose as our decision makers. As the word trust and trustee implies in it, we want to choose people that we trust. Right? So it's important to choose people that we trust. They don't have to be a financial genius. They're always able to get help if they need to from a lawyer, from a financial advisor, from an accountant, that sort of thing. So that is the way that we handle security and privacy when it comes to a trust. We do, because these documents are not filed with a government agency, with the entire estate plan, we do want to make sure first, that the clients have the original. If you came to my office, you know, I'm not surrounded by filing cabinets here, so I do not keep originals. Those go to the client. I always maintain a digital copy, which is not a draft. It's after it's signed, after it's notarized. I always maintain a copy of that. Make sure that my clients have a copy of that, and typically advise them to get those digital copies also to the people that are involved with their estate plan, because oftentimes original copies can be just as good as originals. So if you have any questions about this or anything else related to estate planning, you can always follow this account for more estate planning information. I've got over 1,000 videos out there. There's probably one of them answering a question that you might have. But if you do have any questions, drop them into the comments. I'm often able to answer them. Sometimes I'm able to answer them by video. And if you have any questions about this or anything else to relate to estate planning, and it is time to get that estate plan set up, if you're in California, you can set up a time to meet for free. You can find my email address and my website, ocestateplanlawyer.com, or you can just go to my last name, pevney.com, and we can set up a time to talk for free. Remember, you do need to be serious about setting up an estate plan, and you do need to live in California. So I appreciate your time and I appreciate your attention, and have a good one.